Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to The View from Mayer Brown, our regular employment podcast. Today we're doing something a little bit different. We give regular seminars to clients, and we've just done one which is an annual update, looking forward, looking back over the last 12 months, cases that have been decided, what do they mean for clients, and looking forward over the next 12 months, what's coming next. And we thought we'd try an experiment. So I'm joined today by Chris Fisher, who's the second partner in the employment team, and by Catherine Fox, senior associate in the team, who did all the donkey work on the seminar in terms of doing the presentations. I just got to chair. But I've asked them both to come along today and talk about what's coming up next. So focusing on the future for employment law rather than what's come up over the last 12 months, because I did an end of year podcast, top 10 cases for 2018 and so on. So this is looking forward. This is the looking forward section of the looking forward, looking back seminar. So Catherine, I think you got the short straw. You get to go first. And one of the things that you were talking about in the seminar was gender pay gap reporting. We're at a stage now, I think we're into the second year of gender pay gap reporting, so we've had a further set of results in April 2019. What's that tending to show? What, if anything, is the picture that's becoming apparent?
Well, the figures for this year show that there is a 17.9% pay gap in favour of men based on mean hourly pay. This is actually down from last year when it was 18.4%.
Just feel that progress.
Well, I think there are still calls that the regulations are just not tough enough and haven't caused employers to take sufficient action to address the ongoing pay gap.
Yes, well, you can see that with limited progress like that, that wouldn't be entirely surprising. So you say that there are claims that are there are calls for changes. Where are these sort of claims calls coming from? Are any in particular that stand out for you in terms of what the alternative might be to the current state of affairs?
Well, last year the Business, Energy and Industrial Strategy Committee made some recommendations for reform. They made a number of proposals, and those include requiring employers to have an action plan, setting out a 5-year strategy for how they'll close the gap against measurable objectives and targets, and they'd be required to monitor progress against those and report on those. So that's one proposal. Another is that there will be fines introduced for non-compliance, so for employers who either report late or who fail to report at all. And another proposal that's come through is whether to reduce the threshold to those employers who employ 50 or more employees by 2020. Obviously, at the moment, it only applies to employers who employ 250 or more employees. But so far the government's resisted that.
The reduction to 50 employees,
exactly.
Which expanded quite significantly to the number of employers in the UK. One of the bugbears has been the failure to have any really meaningful sanctions. And so to the extent they're talking about introducing fines, although it's not compensation to people who the employees directly affected, it would at least allow for some sort of sanction, because we saw a number of companies just didn't report at all. Certainly. And then there were some well-reported stories of nonsense statistics being reported as well, where people were claiming impossible non-differentials.
Yeah, that's exactly right. I think there's been some uncertainty as to what, if anything, the Equalities and Human Rights Commission can do to enforce the legislation.
Yes. So that would certainly seem to plug a gap. Although generally, I think our impression has been that employers take this stuff quite seriously, or certainly our clients have been taking it quite seriously. So it may be that that's of less direct impact to them. What about plans to expand the legislation? Because there's been some talks around taking it beyond gender pay.
Yep, yes, that's absolutely right. The government's proposing to expand reporting into the ethnicity pay arena in the private sector. Actually, some public sector organisations, such as the civil service, already publish ethnicity pay data. So expanding into the private sector is the logical next step. A consultation's actually been launched on this, but it acknowledged that one of the major difficulties for employers will be defining the ethnic categories to be reported against, given the variety of factors which can obviously affect ethnicity classifications. Another practical difficulty will be employers actually getting hold of the data. Ethnicity is special category data, and so employers would need employees to provide that information voluntarily. There's no legal obligation, obviously, to disclose with which ethnic group an employee would identify with, and nor is there a legal obligation on employers to collect ethnicity information. And so collecting complete and accurate data in order to allow employers to report will be quite tricky, I think.
Yes, and I suppose you've got the problem, you allow people to self-categorise. It's clearly ripe for abuse at that stage, but yes, I can see that. So that's something that's out there as a possibility, but isn't a decision as yet that that's going to happen. Yeah,
that's right. So the consultation closed back in January, and we're currently waiting for the results.
Yes. Okay. All right. Okay. Well, that sounds. So that's a number of developments there. Chris, you were going to talk about 4 cases that are in the pipeline and are at the sort of latter stages, senior courts, as it were. Yep. And I may indeed ask you very unfairly to speculate on what you think the outcome is going to be. And then we'll mark you. We'll come back on a later podcast and say, Mr. Fisher, you got.
It's me and Mark Lawrenson prediction. So, yes, that's right. We touched on 4 cases in the seminar, which are in the Supreme Court this year, or should be in the Supreme Court this year. 1 has been in the Supreme Court, and the other 3 are waiting a date. The first one was, and they're all very different cases, but obviously going up to our very top court, so quite interesting. The first one was the Morrisons data breach case, which I think many people will know is the rogue IT audit employee within Morrisons who one Sunday afternoon from his personal laptop uploaded the payroll data of about 100,000 Morrisons employees to the dark web, and also circulated to various newspapers. And there was no question he was a rogue employee. He did it deliberately to damage Morrisons' reputation. And it was a criminal offence. What he did, he was sentenced to 8 years in prison. But the Morrisons were then faced with a civil claim under the data privacy law by the employees, who said their data rights had been breached, and that Morrisons should be liable for that. And in a decision that I think has worried, understandably, many employers, whilst the Court of Appeal said that Morrisons wasn't directly liable for a breach of the data privacy laws because they hadn't really done anything wrong. This was a rogue employee they couldn't really have done much about. They were vicariously liable for what their employee did, which is the traditional principle of vicarious liability, despite the fact that it was a malicious act done with the intent to damage them. So one of the arguments was, to the court was, the court, if you reach this finding, you are facilitating what this employee wanted by opening up Morrisons to what will be an absolutely enormous compensation bill if all 100,000 employees are awarded
100,000 times 1,000, how much?
It's
a lot of money.
It's a lot of zeros, yes. So and so hence the obvious appeal, because it's worth so much money. So we'll see what the Supreme Court say about. I think predominantly vicarious liability is the key is the key issue. And I mean the Court of Appeal's answer was, you can just get insurance for this, and obviously most of our clients will be looking at cyber policies. Yes. one would normally expect there to be some sort of exclusion for dishonest or malicious acts by employees. So I think this is one to check if you are, if clients are looking at cyber coverage at the moment, to check something like a Morrison's type situation.
Yes, good point. And whilst you hope they'll be relatively rare, if it does form an opportunity for a disgruntled employee to damage an employer, then who's to say others won't follow?
Yeah, exactly.
Okay, so Morrison's.
That was Morrison's. The second case, which is waiting for a date in the Supreme Court, is the Uber gig economy case, which I think, again, is probably the most well-known of various gig economy cases that have been running through the courts in recent years. And this is really all about whether Uber drivers are self-employed, as Uber would have everyone think, or are they workers? Are they this intermediate category of individual that we have in the UK? They're not employees, but they're not self-employed either. They say that they are workers and so entitled to holiday pay and minimum wage. What Uber have very carefully set up their documentation in a way that portrays an arrangement of them simply providing a tech platform to the drivers, and they're no more than an agent for the drivers, and any contract that is in existence is between the driver and the passengers they pick up. And that was Uber's fundamental case. We are not a taxi services firm. We are a tech company that provides a software app, and that's all we do. The Court of Appeal said, well, yes, that is what the documentation says, but we don't believe that reflects the reality of the situation, and we are going to pretty much ignore those contracts. And we will look at what's really happening, and what we think is really happening is Uber is a taxi services firm, and the drivers are the skilled workers that you use for your taxi services business, and that's how you make your money. And I think there was one dissenting judge in the Court of Appeal who said, no, you can't do that. You can't simply ignore contractual documentation.
And especially because I think, am I not right, that the Uber's argument said, look at taxi firms, and there are plenty of cases that say taxi drivers are self-employed, so we're not doing anything outlandish in the way we're operating, and therefore you can't go from our documents are wrong to finding alternatives.
Yes, exactly. And
that found favour with one of the Court of Appeal judges, didn't it?
It did, there was the dissenting judge who believed that the documentation stood up and were genuine and were not a sham, and therefore the court shouldn't have looked behind them. I think the court said no. They seem to be saying that where there was an inequality of bargaining power, they will be more inclined to look behind contractual documentation. And so I think this is an issue that concerns us and our clients, because we draft documentation for our clients, and the extent to which a court can ignore it and look behind it is obviously highly relevant. Whether it's a gig economy case or any other form of atypical worker where you are drafting a contract in a way to achieve a certain level of status for that person. So I think the Supreme Court decision will be obviously a very important decision, particularly on that point of when can the court look behind contractual documentation, and is it only where you have an inequality of bargaining power, or is it generally where our clients are hiring highly paid consultants, for example? There's probably no inequality of bargaining power there.
Often it's quite the other way around.
It may be the other way around, but nonetheless, can the court say, well, that's all very interesting, but we are going to look behind that and ignore that contract?
That'll be an interesting one. I do have to confess to a slightly unfashionable sympathy for Uber. I think their arguments are not as bad as they've been categorised, but I'm not sure I'd give much for the likelihood of a successful appeal.
Yes. So I think So my prediction on that one.
Go on, Morrison's. Away goals defeat.
Morrison's, I think, will stay with. I think will stay against Morrison's. I think Uber will certainly stay against Uber. So I think those will stay the same.
So next up
is a whistleblowing case. Again, another one where we should get a date in the Supreme Court this year. It's a case of Royal Mail and Jutti, and this was all about the key element in every whistleblowing case, which is that the employer must be motivated by the employee's whistleblowing disclosure in order then to be liable for the whistleblowing claim, whether that's that they were dismissed or whether they were subjected to some detriment because they blew the whistle. There is a motivation element that the employer must have acted because of the disclosure.
Yes.
And so Jutti was all about a scenario where the decision maker within the employer wasn't actually aware of the disclosure that had been made. But there was an argument that they were perhaps manipulated or motivated by someone else, by a co-worker.
So the Iago.
The Iago character.
I love the fact that we still use Shakespeare to explain employment law, but anyway.
Exactly. Yes, nothing like a High Court judge for a good Shakespeare reference. So the facts in Jutti very briefly were Ms. Jutti was a Royal Mail worker. She felt that Royal Mail were breaching their Ofcom regulations and various processes and procedures, and she blew the whistle about that to her line manager. Her line manager did not want this being reported anywhere further, and so persuaded, to put it lightly, Ms. Jutti that she might want to rethink her complaint and withdraw it. And Ms. Jutti's case was fearing for her job. She duly did withdraw her complaint. However, what appears then to have happened is that the line manager set about possibly looking to manage Ms. Jutti out of the organisation by initially putting her on a performance improvement plan. Ms. Jutti's case was that the targets were unrealistic, and really it was just designed as a way eventually to manage her out of the business. She went sick, filed a grievance, and ended up leaving the business. The reason she left, she was dismissed because another manager came on board who did not know about her disclosure and looked at the performance issues that had been alleged and followed through the performance process and ended up dismissing Ms. Jutti for performance reasons. And so the question became that it was accepted that the line manager's implementation of the PIP had been motivated by the disclosure, but the dismissal decision maker did not know about that disclosure. He just looked at the performance concerns and judged that she was a poor performer and therefore the dismissal was justified. And in the Court of Appeal, they said, well, in that scenario, you cannot attribute the line manager's motivation to the dismissal decision maker, and therefore there could be no whistleblower automatic, unfair, unlimited compensation dismissal placed upon the Royal Mail.
Right.
They did say there may be other variations of those set of facts where that line manager may have been more involved in the actual process. So, for example, if you take a disciplinary or a grievance process, they said, which ended up leading to a dismissal, and the line manager in question had been involved in the investigation process, for example, they said now that may be enough to infect the ultimate decision to dismiss and attribute that motivation to the company. And there were various other gradations of that, and I think what will be our advice to clients is always, if you can, separate out any whistleblowing issues from your other processes, whether it's a disciplinary process, a performance process, or a redundancy process. If you have someone who blows the whistle in the course of that, pull that issue out and have it dealt with separately, because in that way you have a better argument to say, well, the person who made the decision on your performance or your disciplinary or your redundancy did not know and was not involved in the protected disclosure that you made over here, and that was dealt with by someone else. What you can't always know is if you have a line manager that you do not know has been improperly motivated by a disclosure and is infecting your process. So again, it will be interesting to see what the Supreme Court says about that, where that line is drawn, and when will that line manager not infect the process.
Yes, and presumably there was a potential claim against the Argo manager themselves, for which query Royal Mail might have been liable. So this might be one of those really tough cases where everyone figures out after the event, well, the way you deal with it is this. You sue the manager. But often as well, what you see is that the claimant will, during the disciplinary process, be going, it's because I'm a whistleblower. Yeah. So the manager doing the disciplinary will be put on notice by the alleged whistleblower, this is actually because. So then that sort of plea of ignorance that won't work.
Yes.
So I also wonder whether if she put in an appeal against the decision to dismiss, and then is trumpeting loudly, I got dismissed, I accept my manager didn't know this, but I got dismissed, it's because I'm a whistleblower. Appeal panel, now you are on notice, this is my argument.
Yeah.
Whether she'd have,
Yes.
that would have been a route. But it'll be very interesting to see.
It will be interesting to see.
Because I can understand why deeming someone to have been dismissed by whistleblowing, by a manager for whistleblowing, carries a stigma for the manager who has been found to have got it wrong, even though they are personally completely innocent.
Yes.
Which feels,
Yes.
it's hard cases, bad law.
Yeah, exactly. Although at the same time, where you have a manager who perhaps is, putting together a performance plan for no good reason that leads to someone's dismissal, you can see from that high-level view why there is some justifiability for the liability.
Okay, what do you think?
That one, I think will stay the same. I think again, I think it will pretty much draw the line. I don't think there'll be liability. Or so rather, I think there will be liability for the company on that one. Sorry, I think the company will...
The duty will lose.
The duty will lose.
Because the
yeah,
manager
exactly.
didn't know.
On that,
No,
whether or not she will have the chance to pin liability on the line manager for the
Roger.
detriment and claim her dismissal losses, that may be something that will go the other way. But
yes.
yeah.
Interesting. Okay, fourth and last.
Fourth and last is a non-compete covenant case, which this is the one that's already been in the Supreme Court in January, and we're waiting for the decision to come out. It's the case of Tillman and Egon Zehnder. For those people who have non-compete clauses in their contracts, you probably will know about this case. Many people are watching it with great anticipation. As everyone knows, the general principle with a non-compete clause is if it is drafted too widely, then the court will ordinarily strike it down. They won't look to reduce it. They will just strike it out of the contract and it will be completely unenforceable. If there are words within a covenant that they can remove without affecting the meaning of the rest of the clause, then they may sever the offending words, and in those cases sometimes they will save an otherwise unenforceable covenant. In the Egon Zehnder case, there was a non-compete clause in one of their executive search managers' contracts, and it was the usual one that precluded her from being engaged or employed or concerned or interested in a competing business. And what it didn't have, which you often see, is the additional words in a sort of boilerplate form that say that this would not stop you from holding a minority investment in a publicly quoted competing company, normally up to 3 or 5% shareholding.
There's the figures we see, aren't they?
Yeah. And it didn't have that in there. And Ms. Tillman therefore used that argument to say, well, on that basis, not that I'm looking to take shares in the competitor down the road that I'm about to join, but because I couldn't do, that makes the clause too wide, and therefore the court should strike it out. And the court did. The Court of Appeal said, yes, we agree with that. Interested in certainly covers shareholding, and so the wording on its face does stop a minority shareholding. And we are not going to sever any of the offending words. We're not going to sever the words interested in, because we don't think we can do that, because that would be affecting the meaning of the rest of the covenant, and it is one entire covenant, and we can't delete words from within a covenant like that. They said that was taking the severance principle too far, which I think some people felt was surprising. I think some people felt they might be more willing to save what both parties otherwise intended to be an enforceable non-compete clause. So I think this is interesting. I mean, we'll see what the Supreme Court say about it. I think they'll agree with the Court of Appeal that interested in includes shareholdings. I think in that case, I think where they may come down is maybe a different view on the severance issue. They may perhaps be more willing to apply a different approach to the severance principle. But the impact is huge for any clients who have non-compete clauses. If you do not have the carve-out for minority shareholding, then you certainly need to be looking at that and considering how you deal with that.
But it also may go further than that, because how you structure your covenants may need to be revisited in the whatever they do with the blue pencilling. So that still feels like the hardest one to call. Let's assume it's decided by penalties. Come on, I've been working towards that.
I think on that one that they will. I think they might reverse it. Actually, I think they may come to a different view on the severance on the blue pencilling point to try and save the covenant. I'm not convinced, but I'm going to go out. I'll go with that one. That the employer will actually win that one.
So, Catherine, if you have to say Chris has got any one of those outcomes wrong, would you pick a particular case where you disagree with the outcome of that, or do you think would you be broadly in agreement?
I actually am on agreement in all of those.
All right.
I think certainly in the last case, I think there's scope there for the Supreme Court to make a difference.
Yes. Well, obviously that'll come up in a podcast in due course,
Yeah.
along with Mr. Fisher's score.
Yeah.
So, Catherine, back to you. The government's Good Work Plan was something you were discussing in the seminar.
Yes.
Start with it. What's the Good Work Plan intended to achieve? What was it driving at? And then we'll talk about the legislation that's coming out of that.
Sure. So the Good Work Plan really stems from the Taylor Review, which many will remember from back in 2017, which had the key focus of improving worker rights. So the follow-on from that was the government's Good Work Plan, and that was described as being the biggest package of workplace reforms for over 20 years. It, as I say, follows on from the Taylor Review and has the overall aim of improving worker rights. There's been a couple of things that have come into play already off the back of the Good Work Plan, already introduced. A key one that many employers will already be aware about is the requirement for employers to provide itemised pay slips to workers which show the number of hours paid. But there are a number of other commitments that were set out in the Good Work Plan, and off the back of that there has been draft legislation published which suggests that there'll be several more changes coming into effect from 6th of April next year. So a couple of key ones to note there. Firstly, a right to written statement of terms for workers from day one of their appointment. So we're familiar with the right to a written statement of terms for employees, but this is obviously extending that into the worker arena. And secondly, the proposed abolition of Swedish derogation clauses. So the clauses which allow employment businesses to avoid paying agency workers comparably to direct recruits if they have a contract in place which gives the worker a right to pay between the assignments. As I say, draft legislation in place to abolish that from next year. And whilst this is all obviously very much in draft at the moment, there's nothing to suggest that it won't be coming forward.
The bit about itemised pay statements for workers makes sense. People understand where they stand. A bit about statement of terms and conditions for workers, again, it helps clarify things. That feels like the sort of thing, it's not that surprising that a Conservative government would bring in. Mm-hmm. The Swedish derogation, though, it seems very odd that this government is proposing to abolish that when that seems to be pretty obviously a pro-employer derogation, cutting down on the scope of the agency workers regulations. It seems odd that they've latched onto that.
Yeah, it does, and there hasn't been much background to that point, explaining why that's become a key focus.
Yes, so it's odd because the agency workers regulations are hardly terribly popular, and you can imagine, if we ended up in a no-deal Brexit, subject to whatever deal we do in a no-deal Brexit, agency workers regulations might be top of a list or close to the top of a list of employment regulations that some people would want to see removed.
Yeah, quite.
So it's an odd one to be pushed through, but as you say, it's in play, and no indications at this stage.
That's right.
That it won't follow through.
Yeah.
Okay, good. Chris, back to you for the last one then, which is IR35.
Yes.
Tell us as little as we need to know about IR35, please, Mr. Fisher.
Yes. Employment lawyers talking about tax law. That's,
what could possibly go wrong?
I can hear my tax colleagues. groaning at
Yes.
their desks, but I will do my best. So IR35, from a very basic point of view, is changing next April, and IR35 is the law that concerns where clients and individuals agree to set up a contract where the individual will be a self-employed contractor. But the way they do that is they have an intermediary company, normally a company in between the individual and the end user client. A very common form is what's known as a personal service company, where John Smith will set up John Smith Limited as his limited company, and the company that contracts with the end user client. Often it's more sophisticated than that, and there may be multiple layers of intermediary in between the end user client and the individual, with multiple umbrella companies and agencies in between. Now, at the moment, our advice always to clients is if you're contracting with a consultant or a self-employed contractor, rather than contracting with them directly as an individual, it is better if they have a personal service company or there is an intermediary company available for you to contract with that company. And the reason for that is IR35, because IR35 is a taxing provision which whereby the HMRC says, well, if we ignored those intermediary arrangements and that individual was just working and contracted directly to the client, would they be considered an employee applying the tax law tests for employment status? And if so, that individual should be paying employment tax and national insurance. But the entity who pays that tax and national insurance will be the personal service company, or the company one level up from the individual.
Right.
That's the critical point. It will not go higher than that to the client entity. So
So it's the individual's own problem, in effect, rather than
yeah.
the customer / alleged employer.
Yeah, exactly.
Right.
So it can be used as a shield for end user clients from that ultimate tax liability. Now, the HMRC obviously are not recovering the PAYE tax and NIC from these personal service companies. Often they don't have very much value in them because they are just one person owning that company. And what they've already done in the public sector is amend the IR35 intermediaries legislation, and they are proposing to introduce effectively that same amendment into the private sector next April. And the two key changes that are going to come in are, number one, that it will be for the end user client to make an initial assessment as to whether or not the end user individual worker would be an employee if they engage them directly. So they are the ones who have to carry out the IR35 assessment that hitherto that's for HMRC to come in and carry out. So there will be a positive requirement on the end user client to carry out this assessment and then inform the agencies down the chain, whether they're agencies or personal service company, and the end user individual of that assessment. And then there will be some process, it seems, for that to be disputed, discussed, debated, but ultimately the end user client will have satisfied its obligation. And provided it does that, the liability then for PAYE tax and NIC will move to the entity that pays the personal service company. So it moves one level up from where it sits at the moment. Now, the problem obviously for end user clients is where they are the entity paying the personal service company, that is the end user client. So the liability,
the customer,
so this liability will move upwards to the customer. If there is an agency in between, an intermediate agency that's contracting with individuals through personal service companies, which a lot of employment businesses do, that will be the fee-paying entity that HMRC will look to operate PAYE and NIC. So I think there'll be two scenarios, but one certainly may well involve clients becoming primarily liable to operate PAYE and NIC directly with HMRC, even though they are contracting with a personal service company and a self-employed person.
So just on that, any indication that it's going to be impossible to get an indemnity from the individual providing the services, so that at the end of the day the costs of the tax risk can be passed back?
don't think there's any indication that I've seen in the consultation paper, and this at the moment is a consultation paper that I think actually closed yesterday. So we haven't seen the draft. So it's too late now.
Too late.
For you to get your objections in or support for this measure. But we haven't seen the legislation that's going to come out, because I think the government recognises that it's a slightly different scenario to the public sector scenario. So they are talking about changing the way it operates in practice. But I haven't seen anything in the form of anti-avoidance or inability to take indemnities where it's possible to do so.
And subject to what you just said, which is we haven't seen the actual legislation, it doesn't mean it's the death of personal service companies, because what we're talking about here is a taxing measure, and personal service companies also form a beneficial defence against claims for employment status, for employee rights, because if you haven't got a direct relationship between the customer and the individual, it's harder to find an employment relationship for employment law purposes.
Correct.
So I don't think it sees the end of personal service companies, but it does mean that people are going to have to be quite careful about the tax risks associated with that.
I think that's right. I think whereas before you could say to an end user client that the tax risk is very, very low, because HMRC will not be able to come after you because of IR35. That will no longer be the case. So I think clients are going to need to really sit down and assess, do we really think that this consultant that we've got providing services is self-employed? And maybe we do. And certainly if they're operating through a personal service company, that will be one factor both for an employment status and in the tax law tests as well, which are not the same but similar, that will be taken into account. So I think there will still be cause for individuals operating that way, but what clients will need to do, which they haven't had to do so far, is to make that assessment, to think. And I think that goes really for across the workforce, where clients are using, IT contractors, which often will contract through personal service companies, possibly linked up into umbrella companies and managed service companies. They will have to make the initial assessment. It may be the liability then sits a little bit further down the chain if there's another entity paying the fee to the individual's personal service company, but the client will have to sit down and think, do we think this person would be an employee if we engaged them? If we stripped out all the intermediate layers, would they be an employee?
Interesting times.
Yes, indeed. So, and I think if we're clients who are operating with agencies, I think it's worth having a dialogue, now about, how are they proposing dealing with these changes in terms of the way they operate, because it may be they will say, well, we are going to operate PAYE and NIC on the workers that we provide through our agency, and we're going to stop providing people, engage people through personal service companies, or where we do provide them with personal service companies, you end user client don't need to worry because the liability will be on us. Now, if that's the case, then certainly you would want an indemnity in your terms of business with that agency that they will retain the liability for tax and NI for those people.
Good point. Fascinating. Okay, as long-term listeners to the podcast will know, when we ever have a guest on, we always like to finish with a book or music round, films indeed, and I see no reason why my colleagues should be exempt from this. So Chris, why don't we start with you? In terms of film, book or music, something you'd recommend in one category?
Okay, not all of them. I go for a book, which is I read recently. I can't say it's a classic piece of literature, but I enjoyed it. It's a good holiday read. It's a new book. It's called Where the Crawdads Sing.
I've not heard of this.
Stay with me. It's by Delia Owens. It was her first novel. She is a nature science writer.
Right.
This is her first piece of fiction, I believe. And if you need a better recommendation, I did check this, and it's the Reese Witherspoon Hello Sunshine Book Club #1 choice for 2018. So if that doesn't sell it to you, I don't know what will. It's very briefly. It's coming of age, 1950s, 60s America, drama, a bit of courtroom drama. It's about a young girl growing up in the swamplands of North Carolina, so you've got the race issues going on in the US at that time. I really liked it because it's a sort of a mystery, a bit of courtroom drama, but the way it's written is very good. She writes a lot about the nature, and her descriptions and depictions are fantastic because she's a nature science writer. So I recommend it. Delia Owens, Where the Crawdads Sing.
Fascinating. Okay, so Catherine, film, music, or book? Come on.
Following that, well, I'd been asked for what my favourite film might be. And so I'm going to go for a classic. Some might say overrated classic, but I love it. So It's a Wonderful Life. Obviously only watched once a year. Good old family tradition to put it on at the end of the day, at Christmas Day, and get those feel-good feelings. So that's my number one choice.
You know, you're the second guest in a row. So I did an interview with the president of the EAT 2 weeks ago, and that was his film. He said he opted for the film round. So you're in good.
Well, there you go. Yeah, certainly in good company there.
Yes, I'm not sure about it, I have to say, but then, And on that note of dissent, Catherine, Chris, thank you very much for submitting, for agreeing to take part.
Pleasure.
I use agreeing in air quotes, of course, but that was really interesting. And obviously, if anyone's got any questions or comments, please get in touch, and we'll be happy to follow up and let us know if this has been useful, because we've certainly enjoyed doing it. So thanks again for listening. Goodbye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.